name is Robert Weaver. I would like to present to you my draft of corporate bylaws that I have formatted for our clients. If you look to the right of the screen, we see that the statute that governs corporate names, which says a corporate name must contain the words corporation, incorporated, or company, or any abbreviation such as Corp, Inc., or Co. We see in the Article 1 of the bylaws that our clients have chosen to adopt the classification of Inc. for incorporation. In Section 1 to the left of the screen, clearly the new corporation has chosen Tennessee as its state of domicile. I have left the final date blank for final editing by our supervising attorney. Section 2 shows that the corporation is organized and governed by Title 48 of the Tennessee Code. Then look at Article 2, which is titled Offices. This section contains information pertaining to the registered office of the corporation and the name of the registered agent. The section complies with 4817-101 on the right of the screen, which says that a corporation must continually maintain in the state a registered office and registered agent who may reside in the state. The registered agent can be a domestic corporation or a non-profit domestic corporation as well as a foreign corporation. As we see from the Articles of Incorporation, Mr. Harris has taken the responsibility of the registered agent for the corporation. Section 2 outlines provisions in the Articles allowing the corporation to seek additional offices and locations known as foreign businesses and other states that it is not domiciled in, which our clients have the intention of opening an additional location within the state of Kentucky. Article 3 of the bylaws, titled Meetings of Shareholders. Section 1 of this article complies with 4817-101, which is on the right of the screen, says in Section A, at a stated time and fixed location, the corporation must hold an annual meeting of shareholders. Section B goes on to explain that meetings can be held within the state or outside the state, but if no such location is stated in the bylaws, its annual meeting shall be held at the corporation's principal office. Although the bylaws give the board of directors discretion to make a determination where the meeting should be held, Article 3, Section 2 gives additional guidance to the corporation governing election of board of members and any additional business that needs to be addressed at the time of an annual meeting. Article 3, Section 3, titled Special Meetings. This section complies with 4817-102, which says that a corporation shall hold a special meeting of shareholders, persons authorized to do so by the charter or bylaws, which allow a shareholder or shareholders with at least 10% of the issued and outstanding voting stock of the corporation to call a special meeting with notice, and the notice must address the reason for a specific purpose to be handled at the meeting. That we can look at it in Article 3 and Section 4 is titled Notice of Meetings. It complies with 4817-105, which says that a corporation must give notice to shareholders entitled to a vote, a written notice no fewer than 10 days, nor more than 2 months before the meeting date. The notice shall give the date, time, and place of the annual meeting. The bylaws reflect this exact information with the exception that if in the case of a special meeting, the notice must give the purpose of the meeting. The section that we can look at is Article 3, Section 5, which is titled Quorum of Meetings. This section complies with 4817-206 by stating that shareholders may take action at a meeting if a majority of outstanding shares of the voting group exist and it will be recognized as a quorum for a specific purpose, other than to object to the holding of a meeting. That we can look at in Article 3 is Section 6, which is titled Proxies. This section complies with 4817-203, in which it allows a designation of a proxy for voting of a shareholder at meetings, which is stated in Section A of the statute that a shareholder may vote in person or by proxy as long as the person has provided written notice of their desire to have another vote in their place. The bylaws do not limit the instruments that the person can serve to notify the corporation of this desire, and complies with the statute that an election of a proxy vote is for the duration of 11 months unless the notice states that it should be for a longer period. Section we can look at in Article 3 is Section 7, titled Voting at Meetings. The statute 4817-209 on the right of your screen states that shareholders do not have the right to accumulate their votes for directors, and the directors are elected by the plurality of votes cast by shares at which a quorum is present. We see that the bylaws reflect the same language contained within the law. If a quorum exists and action on a matter is approved, directors shall be elected by a plurality of casted votes by shares which are entitled to one vote on each matter. Next, look in Article 3 at Section 8, titled List of Shareholders. We again see that the bylaw mirrors the statute 4817-201, which says that a corporation must maintain a stock ledger with the names and numbers of shares, addresses of the stockholders. The list must be in alphabetical order, and the corporation must make this list available 2 days before an annual meeting of shareholders. A complete list of shareholders entitled to vote at the meeting must be at the place of the meeting and present for examination during that meeting. Under Section 9 of Article 3, titled Consent in lieu of Meetings, this is governed by Statute 4817-104. Any action which may be handled at a meeting of shareholders may be taken without a meeting if consent in writing shall be signed by holders of outstanding shares and be delivered to the corporation for filing in the corporation's minute book. The bylaw set a time determination for the record date for the action without a meeting and must be delivered within 60 days of the earliest consent, which is consistent with Section B of the statute. Furthermore, the bylaws set out that a notice of taking of the corporate action without a meeting by less than unanimous vote shall be given to shareholders who have not consented in a written notice no more than 10 days after compliance with Section D of the statute. Under Article 3, Section 10, titled Conference Calls, this is governed by 4817-109, which states that unless otherwise stated in the bylaws or charter, a shareholder must be able to participate in a meeting by use of communication that a person can simultaneously hear each other, and use of such a device shall constitute presence in person at such a meeting. The bylaws reflect the same language as the statute. If we go to Article 4, Section 1, titled Powers of Directors, the bylaws outline the powers of the directors, which is consistent with 4818-101, which says that each corporation must have a board of directors. Section B of the statute states that all powers shall be exercised by the authority of the board of directors, as we see reflected within the bylaws, that all powers of the corporation shall be under the direction of the directors to do lawful acts, business, and affairs of the corporation. To Article 4, Section 2, titled Number, Qualification, and Election, the bylaws set the number of directors at 2. We can see in 4818-103 that the statute sets the minimum number of directors at 1 or more. Section D of the statute and the bylaws both state that a board of directors shall be elected by the shareholders at each annual meeting. Additionally, following Section 1 and 2, under 48-18-102 Qualifications of Directors, this statute says a director need not be a resident of the state or a shareholder of the corporation unless the charter or bylaws so prescribe. And we see in Section 2 that the director need not be shareholders of the corporation. Furthermore, in 48-18-105, in the statute and the bylaws set out that the term of a director expires at the next annual meeting of shareholders, and that although a director's term has expired, the director can continue in his duties until a successor is elected and qualified. As we can clearly see, the bylaws follow each statute as set out. Under Article 4, Section 5, A and B, under 48-18-201, and the bylaws say that the directors may hold a regular or special meeting after the annual meeting of shareholders. Under Article 4, Section 6, titled Quorum and Voting at Meetings, under 48-18-205 and the bylaws, both set the number of authorized directors that shall constitute a quorum. Under Article 4, Section 7, titled Committees of Directors, 48-18-206 and the bylaws say that the Board of Directors may create a committee with one or more directors serving on the committee and serving at the pleasure of the board. Under Section 10 of the same article, titled Compensation, 48-18-111, and the bylaws both have the language that the Board of Directors have the authority to set the compensation of directors. Under Section 11 of Article 4, titled Removal of Directors, the removal of directors by shareholders is governed under 48-18-108 and the bylaws of the corporation, which say that a director may be removed with or without cause by a majority of vote of the shares. Under Section 12 of Article 4, titled Vacancies, under 48-18-110 and the bylaws, if a vacancy occurs in the board, the vacancy may be filled by the Board of Directors. Under Article 5 of the bylaws, titled Officers, Article 5, Section 1 through 5 comply with 48-18-41, in which they describe officers of the corporation under the supervision of the Board of Directors. Additionally, 48-18-402 sets forth that the bylaws, the authority of the officers, and those are outlined within Section 1 through 5. Section 6, titled Term of Office, 48-18-404, and the bylaws set forth that an officer may sign office and the board may remove an officer with or without cause, and that the Board of Directors may fill a vacancy when the officer has given proper notice. Article 6, Section 1, titled Stock Certificates, the corporate bylaws in 48-16-206 say that the corporation has the option of issuing stock certificates. If such certificates are issued, the certificates shall be numbered, registered in the share ledger, and contain the corporate seal. Section 3 details guidelines of 48-16-208 that a transfer of any shares shall be made on the books of the corporation upon surrender and cancellation of the certificates. The statute places a restriction on the transfer and obligations of the shareholders to first offer the corporation an opportunity to acquire the restricted shares. Under Article 7, Sections 1 and 2, both comply with 48-1641 in that a board of directors may authorize the corporation to make distributions to shareholders subject to restriction by charter and subsection C. If the corporation cannot pay its debts or the corporation's assets would be less than the sum of its liabilities. Hello everyone, I just wanted to offer a couple side notes. I noticed under 48-12-107 emergency bylaws, I highly think that this company should have some type of emergency bylaws to designate additional substantial directors in case there's a death of one of or both of directors, since there's only 2 directors that are actually going to be operating the company unless that changes in the future. Also for continuity of the business, and Tennessee allowing it, rather than setting in the bylaws that there should be a minimum of 2 directors, they should put it at 1, so that would allow, if one of the other directors to pass away, they wouldn't have to immediately have a meeting to elect an additional board member to operate the company or the corporation until the next annual meeting of the shareholders. So that's my end notes there. This is the end of my presentation. I thank you for taking the time to view it and hope that I was able to explain the details of this complex document. I look forward to any questions you may have, and thank you and take care.